G'day, it's fugitive Australian journalist Shane Dowling from the website and YouTube channel Kangaroo Court of Australia. Now I'm about to play the video of Justice Paul Tottle reading out a summary of his judgment in the Linda Reynolds v Brittany Higgins defamation case. And that summary goes for about 6 minutes. Then I'll show a video from last year, March 2024, and it's titled How Linda Reynolds Shakes People Down Using Old Defamation Laws. And it's a must read for social media users. Below that, there's a link to the associated article, which is how the WA Labor Party has helped Senator Linda Reynolds shake people down for defamation because WA still has old laws. And just so you know, I got permission from the court to be able to play the video. Justice Paul Tottle reading out a summary of his judgment, and I'll play that now.
Silence is quiet, or rise. Please be seated.
In the Supreme Court of Western Australia, calling Civil Matter 1840 of 2023, Reynolds and Higgins for judgment.
This action was tried over 19 days in August and September 2024. In the action, the plaintiff claimed damages for defamation and conspiracy. She also sought a declaration the defendant had breached a term of settlement made in March 2021, and she sought an injunction to restrain further breaches. The defamation claims arose from the publication of 3 social media posts. My key findings in relation to those posts are as follows. First, the defendant and Mr. David Shiraz published a tweet on 27 January 2022, which conveyed 2 imputations. First, that the plaintiff had pressured the defendant not to proceed with a genuine complaint of sexual assault. And second, that the plaintiff is a hypocrite in her advocacy of gender equality and female empowerment. Both imputations were defamatory. The defendant has not established her defence of truth or any of her other defences. Damages, including aggravated damages, in the sum of $135,000 will be awarded to the plaintiff. Second, the defendant published a story on Instagram on 4 July 2023, which conveyed 3 imputations. First, the plaintiff was engaged in a campaign of harassing the defendant. Second, the plaintiff had mishandled the allegation of rape made by the defendant. And third, the plaintiff had engaged in questionable conduct during the trial of Mr. Bruce Learman for rape. Each of these imputations was defamatory. The defendant has not established her truth, defence, or any of her other defences. Damages, including aggravated damages, in the sum of $180,000 will be awarded to the plaintiff. Third, the defendant published tweets on 20 July 2023, which conveyed the imputation the plaintiff wanted to silence the victims of sexual assault. I have found that this imputation was defamatory, and I have found the defendant has not established her defence of truth, but she has established the defences of honest opinion, fair comment, and qualified privilege. The plaintiff's claim in respect of the 20 July 2023 tweets fails. Turning now to the plaintiff's conspiracy claim. To succeed in her claim for damages for conspiracy, the plaintiff was required to prove that the common and sole or predominant purpose of the defendant and Mr. Shiraz in planning the public disclosure of the defendant's story in early 2021 was to injure the plaintiff. The plaintiff has failed to establish this element of her case, and the claim for damages for conspiracy fails. The plaintiff's breach of contract claim is established. The plaintiff is entitled to a declaration that one of the statements made in the 4 July 2023 Instagram story breached a term of the deed of settlement restricting the making of adverse, critical, or disparaging comments by either party about the dispute that was the subject of the deed of settlement. I am not persuaded, however, that an injunction is a necessary remedy. Before publishing my judgment, which explains the findings I have just summarised, there is one matter of detail I must mention. In the version of the judgment available to the public, one paragraph, paragraph 397, will be redacted to preserve the confidentiality of the matters referred to in that paragraph. In addition, and as a precautionary measure, I will make an order that there is to be no publication of the content of paragraph 397 of the judgment that is to be published today. Subject to that matter, I now publish my judgment, and I will hear from the parties as to the formal orders to be made.
And I'll play the video from last year now, how Linda Reynolds shakes people down using old defamation laws. And I'll play that now. G'day, it's fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, if you're a regular social media user of any sort, YouTube, Facebook, Twitter, Instagram, etc., make sure you watch this video and also go to my website, Kangaroo Court of Australia, and read the associated article, because it's very important in relation to defamation threats. Australia's defamation laws have been updated the last couple of years, and they're just really starting to flow through now, last year or so, with the new defamation laws. But Linda Reynolds is actually currently abusing, well, legally she's allowed to, but she's abusing the defamation laws, because every state and territory except Western Australia and the Northern Territory have updated the defamation laws to the new laws, but WA and Northern Territories are still using the old laws. And that gives Senator Linda Reynolds a big advantage, and that's why she's been instituting various proceedings against various parties in WA, because the old laws are very sympathetic to frivolous claims, and the new laws, defamation laws, make it very hard for frivolous claims to get up. Now, the article I published on Sunday the 17th of March 2024 is titled How the WA Labor Party has helped Senator Linda Reynolds shake people down for defamation. And I'll read you out the first few paragraphs. Federal Senator and perjurer Linda Reynolds is able to shake people down for defamation because the West Australian Labor Party have deliberately failed to keep up with the rest of the country with uniform defamation laws. Linda Reynolds, who is a senator for WA, has instituted numerous defamation proceedings in the Supreme Court of Western Australia, who still have the old defamation laws, against other parties in other states who all have the new defamation laws. It gives Reynolds a huge advantage, as the new defamation laws are designed to weed out the frivolous defamation cases that the old laws allowed, such as the cases Reynolds has instituted. Other federal MPs and senators from other states would not be able to get away with what Senator Linda Reynolds has. While Linda Reynolds might still have had a small chance of winning the defamation cases she has already won, under the new defamation laws, she would have stood no chance in her current defamation cases against Brittany Higgins and her fiancé, David Shiraz. Now, Linda Reynolds sued Aaron Patrick and the publisher of his book, HarperCollins, and managed to get a settlement out of them. How much the settlement was, we don't know, but it was a fairly trivial case, because he wrote in the book how Linda Reynolds dealt with the alleged rape of Brittany Higgins, and she said it was defamatory, so she sued. Exactly how much, we don't know, but I don't think it would have been a huge amount. But irrespective, quite often they'll settle just to save on costs. Now, Linda Reynolds also sued the ACT government recently, and Shane Drumgold, the former ACT prosecutor. and she managed to get a settlement of $90,000, $20,000 for legal fees and a $70,000 payment. Not a huge amount, but once again, they settle on costs. You know, they don't want to spend a huge amount of cost going to WA under the old laws, where they'll probably end up having to pay a lot more anyhow, because they'll have to pay a big part of her costs as well as their own costs, and potentially a small amount. So they settle for the $90,000. Now, Linda Reynolds is still suing Brittany Higgins and her partner, David Shiraz. They're still afoot. They're in mediation. If the mediation fails, apparently middle of this year, it'll go to hearing. Now, once again, that's in WA under the old defamation laws. So that puts pressure on Brittany Higgins and David Shiraz to settle. They did do social media posts, even if it's just a trivial little perception of defamation. You know, Linda Reynolds can still win, and then they're up for the huge costs. So that puts pressure on them to settle and give her a payout of some sort. But under the new laws, defamation laws, Linda Reynolds would have to prove serious harm. Chances of her proving serious harm against Brittany Higgins and David Shiraz for social media posts would be near on zero, because there's literally tens of thousands, if not hundreds of thousands, of posts on social media attacking Linda Reynolds. And so how would Linda Reynolds be able to prove that Brittany Higgins and David Shiraz's social media posts are the ones that caused her any harm? She wouldn't be able to. It'd be near on impossible. She'd have to say, oh, so-and-so read it and caused this all this harm. Well, how's that any worse than all other social media posts attacking her? For good reason, I might add. Now, I'll read you out two key parts of the new defamation laws, and it's from the website Clayton Utz, the law firm website, and it deals with serious harm and also a concerns notice that you have to send nowadays. And it says, insofar as the 2021 reforms were aimed at reducing trivial claims they introduced, concerns notice process, prospective plaintiffs are now required to issue a concerns notice to the publisher identifying the allegedly defamatory material, the serious harm suffered, and the imputations of concern before commencing proceedings. This is a mandatory step, and proceedings cannot be commenced without a valid concerns notice. The process is aimed at facilitating non-litigious resolution of claims. Now, you normally have to wait 28 days after you send the concerns notice before you can institute the proceedings. And serious harm. The reforms introduce a new element to the defamation cause of action. The publication caused was likely to cause serious harm to the reputation of the plaintiff. The new element has not received substantial consideration by superior courts. And he goes on to say, we expect to see the federal court become even more attractive to defamation plaintiffs if they do not have to establish serious harm before trial. The Supreme Courts of Western Australia and the Northern Territory are also currently in an attractive prospect, since under the law of those jurisdictions, serious harm has not been introduced and the concerns notice process is not mandatory. So there's the law firm Clayton Woods spelling it out for their potential clients. If you want to sue in Western Australia or the Northern Territory, you don't have to prove serious harm, and you don't have to serve a concerns notice. Now, you do have to serve it now. Like I said, you have to serve it, then you have to wait 28 days before you can institute proceedings. Now, a prime example of the benefit of that is Kerry Stokes, over the last few years, instituted numerous defamation proceedings against me since 2014, actually instituted 4. And there was never any concerns notices, and there was never any serious harm he could prove. So if he had to institute those proceedings today, they'd all be thrown out before hearing, because he wouldn't be able to identify any serious harm. They were just frivolous and vexatious slap lawsuits designed to silence me from reporting on his corruption. Now, Senator Linda Reynolds has done more damage to her reputation than anyone else ever could have, with all her lies and deception. And the Western Australian Supreme Court, or Western Australian Labor Party, who've been in power for quite a few years, have got a lot to answer for. Why haven't they updated their defamation laws to stop someone like Linda Reynolds abusing it? Now, I suspect it's because of billionaires like Kerry Stokes and Gina Reinhardt, who have a long history of suing for defamation and threatening to sue for defamation, and probably lobbied the Labor government, who have been in power in Western Australia for a long time, to not introduce the new laws. That leaves it open for them to sue and threaten to sue on a regular basis if they want to, under the old laws, which are a lot more suitable for frivolous claims. Now, like I said at the beginning of the video, make sure you visit my website, Kangaroo Court of Australia, and read that article. I'll put a link to the article below this video on YouTube. And there's a lot more information on there. For example, a precedent called Reynolds versus McLaughlin from 2022, where someone who posted a Facebook post was sued for defamation, but it was kicked out because the person couldn't prove any serious harm. And they didn't put any serious harm in their concerns notice. So it was kicked out before trial, before anything, because it wasn't identified in the concerns notice, because they couldn't identify any. That's why. It was a frivolous claim, so I was kicked out on that. So if you are threatened with defamation, just know some basic information like that, basic laws like that, can help you save a lot of money, especially if your lawyer's trying to stitch you up and bleed you dry. They quite often do. And the reason this video and article are important is because there's still people in power and a few nutters on social media saying, oh, we'll sue for defamation. Well, they're not in a position to sue for defamation anymore because they can't prove serious harm. And before they didn't have to. That's why Kerry Stokes was managing to run the slap lawsuits against me for year after year. If he had to prove serious harm, I would have had them thrown out in a matter of months, if not weeks. And Kangaroo Court of Australia is independent media. I'm 100% crowdfunded from viewers like yourself, so please support my Patreon account. I currently have 407 patrons donating $2,345 a month, and I need to almost double that to become financially viable. And you can donate any amount, $3, $5, $10, $15, $20, $30, $40, $50 a month, whatever suits your budget. It all helps out. And the link for the Patreon account will be below this video on YouTube and also on my website. And please hit the like and subscribe button, and please share this video on social media. Other than that, thank you for your time and have a good day.